news and talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For legal advice, you can call the office anytime at 1-800-DeWitt-LAW, or you can also interact with the show simply by sending an email to ask@dewittlaw.com, or you can also call and leave a voicemail as well at 407-53-MOSES. That's 407-53-MOSES, M-O-S-E-S. Every Sunday morning at 10 a.m., you'll learn how Florida's legal issues affect you with your host, Mo DeWitt of the DeWitt Law Firm. Mo will answer your questions to discuss the latest legal issues affecting the citizens of Central Florida. My name is Jay Edwards here with Mo DeWitt. Good morning, Mo. Happy Sunday.
Happy Sunday to you. How are you doing, Jay?
I'm fantastic. So briefly explain, I know a lot of people listen every Sunday for some free legal advice. They'll email us. They'll leave those voicemails. But maybe somebody's brand new. You do this basically just to kind of give back to the community. You guys have been doing this for quite a while here at the DeWitt Law Firm.
Well, we have been. I mean, let's not say it's all altruistic. It's a good way to get our name out there
Sure.
as well. But, you know, as part of this job, we just get so many people who call in on a daily basis, and they don't need an attorney yet. They just have a few legal questions and just need a little bit of guidance. And so that's what this show is all about, where you know, during the week, you know, we're busy as attorneys and we're in court, and unfortunately we just don't have the ability to, you know, answer every little legal question. So this gives those people an avenue to, you know, if they have a question, if they need to kind of be pointed in the right direction, they don't know what to do or where to go, even if it may not be something that we handle in our office, we can try to point them in the right direction and hopefully get them to somebody who can help them.
Awesome. Very nice thing that you guys do. And I'm going to start you off with a question.
All right, let's do it.
I have a listener that wants to know, they were driving a truck and they were delivering a trailer, delivering a sofa on the back of a trailer to an apartment complex.
Okay.
Apartment complex clearly states, you know, one vehicle at a time or whatever.
Right.
And so going through the gate, once they get their truck through the gate starts to close, thinking, I guess, that maybe it's a second vehicle on them, and ends up bashing and like, you know, bending the gate really bad, but also doing damage because they started to drive and I guess started to like drag the gate on it and did damage to, I guess, not only then to their truck, but also to the trailer. Mm-hmm. So they contacted the association or whatever, filed a report and everything with the person that was on duty because it was after hours, and got in touch with the insurance company. But they said now it's been almost 3 months and they keep just leaving voicemails and everything. And they're like, we know we have your report, but it's taking forever for them to finally get something done. They want to know, is there some sort of time limit? Like, do they have within 30 days to start moving forward and processing this claim?
Well, no big surprise. Insurance companies dragging their feet and trying to delay things. The legal standard is a reasonable standard. So a lot of people insert 30 days into that, but the law doesn't actually say 30 days. It's basically a reasonableness standard to resolve the claim and to respond to the claim. Okay. And if they don't do that, they could be guilty of what they call bad faith, which basically opens the insurance company up to some additional liabilities in certain cases. Now, in a case like this, if you're just not getting a response, the proper thing to do probably would be go to the insurance commission here in Florida and basically file a complaint with them. There's what we call a CRN, which is basically filing a complaint saying, hey, insurance company, you're not acting in good faith. And that goes directly to the insurance company. It can affect them in certain ways, affect their ratings and things like that. They have to respond to it through the state. So if they're just, you know, completely non-responsive, that's probably your next step, is to go ahead and file that complaint with the insurance commission here in Florida.
Got to be frustrating because you know that's not your fault. You're just, you know, 100 cars with trailers, landscapers probably all coming through there, and it just happens to be you, and you're probably not the only one that it's happened to. But it's like, man, fix my stuff.
Yeah, I mean, it's probably not a huge amount of damage, but it was damaged. The sensor wasn't working or whatever was going on, and it should be fixed. And they're just dragging their feet, or it's not important to them, but it's important to you. You know? So you got to get them moving.
Absolutely. All right, let's get to another question. This one was emailed to us. It says, I have an ex-husband that was court ordered to pay $6,000 a month permanently. And about 10 years ago during the recession, he was having a rough time financially. And I also had a serious accident that resulted in me not walking for almost 10 months. He decided then he wasn't going to pay any longer and withheld alimony. I had no income. I had huge medical bills. He pressured me to sign a statement to end payments in exchange for $3,000. Now, it was never notarized or entered into the court record, But then he lied to me about his finances and now lives in almost $1 million home. His business is doing well. Wants to know, can I take him to court for past alimony and hope for some type of settlement? The alimony was in exchange for my interest in our construction company.
So there's a lot to unpack there.
Yes, there is.
So, typically after a divorce is finalized and alimony is awarded, the alimony continues to go on until someone files a petition for modification. Doesn't matter even if the parties reach a verbal agreement or say, hey, you can pay me $1,000 a month instead of $2,000. From the legal standpoint, it continues to accrue until you file that petition for modification. And so in this case, there was some sort of stipulation signed. And so it's going to be a question of whether that stipulation was done properly and whether it's enforceable. So the first thing we have to do is take a look at that stipulation. Now, as part of really any legal case, when you enter into a stipulation or a contract, the parties are assuming that they're entering into it with full information. And so there could be a potential fraudulent inducement action here where she entered into this joint stipulation based on fraudulent representations about the other side's finances. And that's why it's so important when you're going through either a divorce or a modification action to properly document what the actual finances are. Because, of course, if there's nothing in writing, she takes him to court, he's going to say, well, I told her all about my finances. She just needed the $3,000 or whatever it was. So she agreed to sign this. And so it's going to be difficult to show depending, first of all, I don't know if the joint stipulation was done properly, if it's been recorded with the court, if it's written on a napkin, we'd have to see that and evaluate that first. But, whether it's a prenuptial agreement, a postnuptial agreement, a joint stipulation or a marital settlement agreement, any of those agreements, you're assumed to be entering into it with full knowledge. And if you're not, then the agreement could potentially be overturned because courts don't want people to be duped or misled, essentially. But it's your job also to do a fair due diligence. You can't say, well, I could have discovered this information. I just didn't bother looking.
I just needed the $3,000 real quick and moved on.
Right.
But now that he's doing really well.
and it could have been a situation where he legitimately had some financial issues. Right. And then, now he's doing much better. But that's why you do things properly. That's why he really should have filed a petition for modification. She should have never signed anything without consulting an attorney. I mean, if you get anything from this show, just when it comes to these matters, just call an attorney.
Right.
Have them review it. It may just cost you a couple $100, but trust me, it will save you so many headaches down the road. She really shouldn't have signed that without doing things properly. And whether this was ever recorded with the court or, actually terminated the alimony or what they did with it, that's a whole different story. But yeah, this to clean up potentially could be a pretty difficult situation on both sides because nobody really did things properly.
Right.
Clearly there was no attorneys involved at this point. And just the procedural processes were not followed. And ultimately it's going to be a factual determination as to whether she can get that stipulation overturned or not, or whether it's even enforceable.
But if she can go and prove that, no, he's been doing well the whole time and he basically duped her, then maybe she's got a chance here.
Possibly, but that's why, when we do financial disclosure, it's in writing. So, as part of a divorce or a modification, you sign a financial affidavit, which shows your financial picture. It shows your monthly income, your expenses, your assets, and your liabilities, and you sign that under oath. And that becomes part of the court file because that way, if someone comes back and challenges the agreement later and says, I was misled, well, you can go right back to the financial affidavit and say, well, this is what was on it. This is what you said was true. And so if they say they were making $50,000 a year, but they're really making $500,000 a year because you get their pay stub or some other information down the road, you can directly point to some document saying they misled me. When those statements are just verbal, it's much more difficult to do that because obviously he's probably not going to admit to misleading her.
Sure. Right. Yeah.
And so now it's a case of he said, she said, which can be very difficult to prove in court, especially, it's a higher burden to overturn an agreement like this. And she has the burden of proof here. So it could be a difficult case for her, again, just depending on what the facts are.
Gotcha. All right. Well, good luck with that. So yeah, a lot to unravel there. Kind of on the same topic, but just I'm going to throw you one from right field here.
Okay.
Talking about verbal agreements. And this might be a dumb question, but you've always heard of the gentleman's handshake, the gentleman's agreement, right? let's say I'm going to sell my car. I shake my hands with my neighbor Bill, tell him I'll sell him my car for 10 grand. And then tomorrow you come along, Mo, and say, I'll give you $11,000 for it. Well, I don't have anything in writing. Does that kind of thing hold up? Or it's like, hey, man, like, look.
Well, typically, there's no consideration for that agreement. If he paid you the money at that point, then you'd have some sort of consideration. There'd probably be a binding verbal agreement. But if it's just a handshake deal like that where no money's been exchanged at that point,
No paperwork or anything?
then probably not. Then
Okay.
you probably don't have so any contract needs consideration technically, which is just some sort of value in exchange for the contract, right? So, an example could be, hey, here's $1,000, hold this car for me and I'll buy it within 5 days or something. And so that there's consideration there. But if you just say, hey, I'm going to buy the contract I'm going to buy the car for 10 grand, and we shake on it, there's no consideration there. There's been nothing exchanged in order for you to hold that vehicle for me. So at that point, you're really welcome to sell it to anybody else.
Gotcha. And with COVID these days, nobody's shaking hands anyway. You're fist bumping.
Or elbow. There was the elbow bump for a while.
Gentleman's elbow bump to agree on it.
I think we're past that stage now.
Yeah, absolutely. All right, we got a couple minutes here. Let's get to this one real quick. Rosa wants to know, purchased a timeshare. I want to cancel it after now I've read the documents carefully. I'm going to send a letter to the address described in the contract, but how do I know that everything is canceled, that they'll return my money back to me? Plus, I guess she got some sort of card and a tablet. What's the best way to return those items so that she doesn't get charged for it?
So you want to send, so in Florida, you have a 10-day cancellation period on timeshare agreements. And it typically starts when they give you, I can't remember the name of the document off the top of my head, but they give you basically a document that outlines your rights for the timeshare. And so usually they kind of give that to you when you actually sign for the timeshare. They're probably not going to tell you that they're giving it to you. So you have 10 days from there to cancel without any penalty, essentially. So what you want to do in this case is you want to send a letter, regular and certified mail, to their address for notices. If you look through the documents that you signed, typically there's an address listed in there where you must send the notice. So you want to send that by regular and certified mail. That way you can show and prove that they received it. And then I would go ahead and probably just send the tablet or gifts or whatever back to that same address. Again, using certified mail or some way that you can trace that it was received and show who signed for it.
Somebody's got to sign for it, cover your butt.
So that you don't get charged for those as well. But we've actually been getting a lot of these questions lately in the office about people wanting to cancel timeshares. And if it's within that 10-day period, you really don't need an attorney for it. You just need to make sure that you send them a proper notice that is regular and certified mail, saying, who you are, what the contract number is, and just say that you want to cancel, really pursuant to Florida statutes. And then from there, you really should have no further obligation under the law.
Is it 10 business days, just 10 calendar days? Does it matter?
Just 10 calendar days.
Okay.
But as long as you get that letter postmarked by the 10th day, because there's what we call the mailbox rule, which is basically the letter is deemed to be delivered the date that it's postmarked.
Okay.
So if it's postmarked on the 10th day and you have proof of that, you should be good.
Kind of like when you do your taxes.
Exactly.
It's just people getting excited and they just end up signing that. Nobody ever reads the small print, unfortunately. But, it's just you get excited, you sign it, they hand you the keys and off you go. And now you realize, oh, man, look at that. Paragraph 2.
Yeah. And those times, sales presentations can be high pressure and things like that. I think some people just sign them just to get out of there, frankly.
Right.
So,
you want your theme park tickets and your $100 gift card to the steakhouse.
Right.
We've all sat through them.
Yeah. Or you get home and you go, hey, this really wasn't the best financial decision for me.
Right.
And, decide to cancel at that point. But yeah, you have the 10 days. That's an important thing to know. It is a strict 10-day window. So once you sign, if you cancel within those 10 days, you can usually cancel without penalty.
Good to know. All right. Hopefully that helps you out with your answer there. You are listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk. We're going to get to more of your questions. If you want to get involved with the show, you need some legal advice, you can call the office anytime. 1-800-DeWitt-LAW and actually speak to somebody there. 1-800-DeWitt-LAW. Or if you want to interact with us by sending us an email, your question, you can email us at ask@DeWittLaw.com. That's ask@DeWitt, DEWITT law.com, or you can also call and leave that voicemail, 407-53-MOSES. That's 407-53-MOSES. Back with more of your questions and get you some great legal advice coming up in just a few minutes. It's the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
Someone ran a stop sign about 50 miles an hour and hit my truck basically head on, and it caused a lot of damage to the vehicle, but also hurt me as well. The insurance company reached out like, hey, we'll make this all go away if you just, sign this and take this money. And even though that was my first accident, I knew that that wasn't the way it should have went. And that's when I decided to call Mo.
So after the accident, the insurance company approached Mark and tried to give him $1,000 to waive all rights to bring a claim. Fortunately, he was suspicious and knew better.
So it was no, if you have a question, just call me at my office or email me here. And I really enjoyed that.
Ultimately, in this case, we were able to recover $110,000 from Mark's injuries.
He's funny, he's approachable, but he also knows what he's doing. And if I knew anyone who's injured and needed a lawyer, I would definitely recommend DeWitt Law Firm. If you're injured on the go, just call Mo.
Mark's a great guy, and I'm so happy that we were able to help him with his accident case.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards, here with you Sunday, talking to Mo DeWitt. And Mo, how can people interact with the show? I know we're going to get to one of our voicemails here in just a second, but that's a pretty cool way. If somebody's got a question, they can call you and leave you a voicemail.
Yeah, absolutely. So that's what the show's all about. You can call and leave a voicemail at 407-536-6737. You can do that any time of day. Shoot a text message there as well if you'd prefer to do that. Or send us an email at askask@dewitlaw.com, and then we'll answer your question right here on the show.
Perfect. We're getting to a lot of your questions here today. So let's go ahead and get to this voicemail that was left for you. This gentleman has a question about fraud alert.
Yeah, Moses, I was listening to you on the radio here. It's about 10:50 Sunday morning. It's the 11th. It's the 11th. Yeah. I had a question, a law question. I'm on the property fraud alerts list for the Seminole County, just in case somebody tries to get into my accounts or try and change things around. Now, my question is, say if I set up a hypothetical situation like where somebody actually does try and, take a lien out on my house or try and get the ownership of my deed and all that stuff, what's the first thing I do? I don't know what it is, but there must be some kind of a procedure to halt it or prevent it from happening again or anything like that. But anyway, it's just general questions about the property fraud alert. And like I said, I am registered. I have been registered with the fraud alert of the Seminole County Clerk Court. And it sounds like a pretty good deal if they let you know when it actually happens. And so that's what I'm up against. Okay. Thank you very much, sir. Have a good day.
All right. So fraud alert. What do you have to tell them? What can you help them with?
So if this were to happen, if someone were to illegally or fraudulently transfer your property, the first thing that you want to do is file a lawsuit against the person who received the property and put a lis pendens on the property, which basically prevents the property from being transferred legitimately after that. Because basically what you're doing is you're putting everyone on notice, any potential buyers, that there's a lawsuit on the property.
Okay.
And so the real risk here is, typically it's fairly easy if someone transfers the property illegally or fraudulently to that person, the fraudster essentially. It's pretty easy to unwind that. You can show that that's fraud.
Mm-hmm.
Where things get really messy is where that person then sells it to a bona fide purchaser for value, a legitimate buyer who knew nothing about the fraud.
Mm-hmm.
And so now you really have two victims. And so then in order to get your damages are only against the fraudster, not the bona fide purchaser for value, because they didn't do anything wrong.
Right.
They thought they were going to purchase the property, legally and legitimately. Now, of course, there's title insurance and things like that you can go after, but that can be messy too. But by filing the lawsuit and putting the lis pendens, it prevents a bona fide purchaser for value from purchasing the property. And so then you don't get into that issue because no one is going to legitimately buy a property when there's a lis pendens on it, because a title company is not going to let them do
Okay,
that.
gotcha. Big red flag.
Big red flag. It basically stops any further legitimate purchases.
Mm-hmm.
And then it's just a matter of invalidating the deed against the fraudster, having the court correct it, and basically issuing a certificate of title back to the real purchaser.
That's kind of
real owner.
That's scary. Like, how does somebody go and do that? Like, is that just you not paying your HOA or something
So
like
I've
that?
never personally handled a case where it was done by a complete stranger. Now I know there's been some cases where, people will own like vacant land and they'll live, in the UK, or they're a foreigner who own land here in the States. And so the fraudsters will kind of look for those type of people because, first of all, you want land because nobody's going to check if anyone lives there, right? It's just a piece of property. And if the person's out of the country, they're not going by. So it makes it easier to kind of have these fraudulent transfers.
Gotcha.
In cases I've seen before, it's usually someone who does a not so smart deal where they say, hey, brother-in-law, let me transfer over this deed to you, and then, you can refinance the property, take some money out on it because you have better credit or something. We'll split the funds, and then you transfer it back to me. And then that person ends up being shady and then sells it off to a third person.
Gets messy.
And then it gets really, you'd be amazed the trouble people can get themselves into. But that's usually where I've seen it more. But there are, illegitimate people who, try to do this fraud. Usually it's got to be on something where nobody's living there, because obviously any buyer is going to go check if someone lives there. And if you're living in the property and they knock on your door or they try to tour the home, you're going to go, wait a second, this place isn't for sale.
Nice try.
Yeah. So usually that's the case, but I'm sure it could happen otherwise. And so, if it did happen, this is what you want to do.
Very interesting. All right, great advice. You're listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's news and talk. Every Sunday morning right here, 10 a.m., you'll get to learn how Florida's legal issues affect you with your host, Mo DeWitt of the DeWitt Law Firm. More of your questions coming up. If you want to get one into, ask at DeWittLaw.com. That's ASK at DeWittLaw.com. Or just like that gentleman did, you can always leave a voicemail as well. 407-53-MOSES, 407-53-MOSES. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's news and talk.
When you get injured on the go, you gotta call Mo, right? I was walking across the parking lot, and my ankle rolled, and I tripped, and broke 4 bones and 4 ligaments in my ankle.
Trip and fall cases can be tough, but in this case, I'm thrilled that we were able to fight for Jamie and get her the justice she deserves.
Oh, my experience with you guys were great. You guys were awesome. You took care of all of my needs. You really put my mind at ease, and I felt really taken care of by you guys. I would definitely recommend Mo if anyone got injured on the go. I would definitely recommend Mo.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's news and talk. Every Sunday morning right here, 10 a.m., you're going to learn how Florida's legal issues affect you with your host, Mo DeWitt of the DeWitt Law Firm. Mo's answering your questions and discussing the latest legal issues affecting the citizens here of Central Florida. And some more great questions being emailed into us this morning. If you've got yours, you can always submit them to ask@DeWittLaw.com, ask@DeWittLaw.com. You can also call, leave a voicemail, 407-53-MOSES. And if you need an attorney, you want to give them a call, they're there anytime. 1-800-DeWitt Law is where you can chat with somebody. That's 1-800-DeWitt Law. All right, Mo, let's get to, I got a whole stack of questions here. We're not going to get to
It's amazing how they pile up like that.
I'm saying they just keep coming in. So, all right, so here we go. I traded in a car June 2021, and in October 2021, I received a letter from a towing company saying that the car was picked up by Florida Highway Patrol and that there's a lien under my name. I contacted the dealer and they were like, oh, don't worry about it. They just want to take your money. So I didn't pay attention to it. To make the story short, I cannot renew my vehicle registration because there's a renewal stop because of that lien. So I contacted the dealer. They provided some paperwork, but the tax collector says that I have to take it to Tallahassee. Is there anything legal against the dealer? Because I'm the one doing the runaround because the car is still under my name. Hope you can give me some help.
Well, first problem was ignoring it.
Right. Yeah.
Don't ignore legal notices when you get them like that, because it's easier to clean it up when you first get the notice than a year from when you get the notice.
Yeah.
And now you're stuck in this issue where you can't renew your tag. Really it's from what I'm kind of piecing together here, it sounds like this lien occurred really before he purchased the vehicle, which means it really should have attached to the vehicle, not to his name. He says his name. I can't imagine it attached to his name unless, it was legitimate and they had his name, because they wouldn't have his name at that time, obviously. But yeah, I mean, really the dealer should be the one who's taking care of this, but ultimately it's your vehicle now. So, really you need to call up in Tallahassee. It's going to take you a while. You're going to be on the phone, try to clear it up, send them the paperwork showing them you did not own the vehicle at this time. And hopefully you'd be able to get that cleared up. Now, depending what happens and how much the lien is, then you may have a cause of action back against the dealer for basically not giving you clear title to the vehicle. Because when you purchase a vehicle from a dealership, whether it's a used car or a new car, there is a you're supposed to receive clean title, right? A clear title without any liens on or encumbrances on it. That is part of the implied purchase of the vehicle. And in this case, it sounds like that was not done, because this lien was clearly on there prior to him purchasing the vehicle.
Right.
So the dealership should be at least liable for the amount that the actual lien cost. And if you had to hire an attorney or something like that to get it cleaned up, they could also potentially be liable for those fees as well. But first, I would probably spend a few hours on the phone. It's going to be a headache, and see if you can get it cleaned up with Tallahassee or the tax collector.
But something that you got to do. And that's kind of the price you got to pay for waiting.
Yeah, I mean, sometimes in these cases, you have to be a little bit of a pain with the person on the phone, and keep asking questions and keep pushing back until you get to the right person to get it cleaned up for you.
Gotcha. All right, let's move on to our next one. This one is, my husband adopted his daughter in 2011 and fostered her prior to adopting her. They are not blood related. He adopted her as a single parent, and she has lived with us since 2010. He doesn't pay anyone child support, and no one pays him child support. We have together supported his daughter. She turns 18 in December, but does not graduate high school until May of next year. She wants to move out at the age of 18 and live with her maternal grandmother. Can her grandmother sue us for child support because she is still in high school?
So under Florida law, child support continues until the child turns 18, or if the child's still 18 and in high school, with a reasonable expectation of graduation before the age of 19, child support would extend until they graduate from high school. So we're talking about probably a fairly limited period of time here. You always say this is America, anyone can sue anyone for any reason. I think in this case, it's probably fairly unlikely that the grandmother would be able to bring a cause of action, because it's not that the parents don't want to take care of the child. And just to clarify, when you adopt a child, you have the same legal responsibilities as a biological child when it comes to child support.
Okay.
If there would be a divorce, if you adopt a kid, you're still on the hook for child support for that kid, even though they're not your biological child. But in this case, it sounds like the daughter is making a decision after she turns 18 to move in with the grandmother. It's not a case where the parents are unable or unwilling to take care of the child. And so I think it's fairly unlikely that a court would award child support in that scenario. There's not a ton of case law on this specific fact pattern,
right?
Because it just doesn't happen that often, because it is such a limited window. You don't see a lot of lawsuits or child support cases being filed because it's really not worth it to pursue the child support for that limited amount of time. So It's unlikely. Of course, anyone can sue anyone for any reason. This is America. Would she ultimately win? Probably not. But it's a possibility. I mean, it's a potential liability, potential risk.
And I mean, you would think, obviously dad's going to want to take care of his, quote unquote, adopted daughter. That's, that's his kid, and probably stepmom too. But it sounds like there's something with her now moving out. They're probably not happy about it. And maybe things just got a little bit ugly. But of course, in the long run, yeah, you're there to, support your kid.
Yeah. And the way around that is, if you're going to continue to financially support the child, even if she moves out, when you make sure you're writing checks or doing some way of tracking the payments you're making to her and labeling it as support. So that way, if there ever is a lawsuit, they can't claim it was a gift or that you don't have receipts or things like that. So we see that a lot where, especially in paternity actions where the parents are kind of getting along and, maybe dad's, sending over, just giving cash or, Venmo or whatever, kind of to support the child.
Right.
Then they get in an argument about something and dad gets taken into court for child support, and now he doesn't have any of the receipts to show that, hey, I've been paying, $700 a month or whatever it is, and it's basically his burden of proof to go back and find all those receipts and prove that he's been supporting the child. Now, there's another issue too. If you're buying things directly for the child, let's say you're buying diapers or clothes or toys, those can all be considered gifts under the law. That's why it's important to, not only track the payments you're making, but also label them as support. And it's better off to give actual cash rather than items, because those can be considered gifts.
Gotcha. All right. Going back to what you said a minute ago about being on the hook for when you adopt somebody for child support. So let's say, guy marries a lady. She's got 3 kids. He's never been married before, never had kids. When they get married, he goes and adopts those 3 kids, just like, how people will do. We're all one happy family now. Right. So now, same thing. Those are now his kids. If they divorce in 6 months, those are his kids now.
Yeah, I've had that case many times. And, I had one that pops into my mind where after they started going through the divorce process, the kids wouldn't speak to him, wouldn't be around him, wanted nothing to do with him, but he was still legally and financially on the hook for them.
Wow.
And, in that case, the mother was absolutely going to make him pay the child support for it. So, yeah, I mean, adopting a child is a big responsibility. Even if you get a divorce, you have to understand what you're getting yourself into. I'm not saying don't do it.
Right.
I'm just saying understand, the commitment that you are making, even if the marriage, goes south.
Because you go into it with great intentions, but I guess you never know what happens down the line.
Yeah, I mean, unfortunately, being a lawyer, going to law school kind of teaches you to always think worst case scenario, which is maybe a very bleak way to look at life.
Right? No, but you have to.
But I mean, in these situations, that's, you always kind of have to assume, what if the worst happens? What does my life look like then?
Right. All right. We got another one here. Enough time for another one. My wife's attorney is claiming our house was purchased with gifted money from her mother under an LLC. This may be accurate from a previous home we lived in when we got married in 2016. My wife then sold that home and purchased our current home in 2019 under the same LLC. But as of February of 2021, my wife and my wife's name are the grantees on the deed, which she signed over as an officer of the LLC. So it says that the attorney claims that the gifted money used to purchase the original home transfers to the new home purchased while married, and the gifted money continues to be a non-marital asset, and I can only negotiate regarding the current equity of the home. So they want to know, I've had my concerns regarding something he said, as it appears that he is just negotiating for my wife and maybe not so much in the middle. If he is being truthful, I don't want to waste your time, but can you tell me if the comments regarding quote-unquote gifted money from the original home purchase to the new one applies and trumps my name being on the deed if the home was to sell? Now, I'm completely lost on this, and I'm so glad I have you here right now. So
we'll dissect it here. So first thing is, it sounds like these people are trying to do an uncontested divorce, basically, reach an agreement of some kind. But there's an attorney involved. And in this case, the attorney represents the wife. Now, he or she may be kind of holding themselves out as, impartial or neutral or trying to help negotiate things. But anytime you have an attorney involved in a divorce, unless they're acting as a mediator, they can only represent one party.
Okay.
So that's, what I tell people when they call this office every time is, hey, if you're calling for an uncontested divorce, that's great. But please understand that I only represent one of you. I can only give legal advice to one of you, because it would be a conflict of interest for me to try to give legal advice to both sides.
Gotcha. Yeah, but that makes sense.
Yeah. So every once in a while, husband and wife will try to come in together and do a consult. We don't allow that because it just creates an inherent conflict of interest.
Gotcha.
You can't ethically do it. So in this case, the person needs to understand that attorney does not represent them. They represent the wife, and you should really go get your own independent legal counsel to find out what your legal rights are.
Okay.
So in this case, it sounds like, basically at some point the wife had some money from a trust, used it to buy one house with the trust, then used it to buy a second house. At some point, the house was only in the name of the trust or her name, and then she signed it over to a deed with both their names on it. Mm-hmm. So under Florida law, when you add a person's name to the deed and put a house in both persons' names, there is a presumption that that house is now marital, and he is entitled to 50% of the equity in that home.
Okay.
There's a few small exceptions out there, some case law that's very specific dealing with If you only did it for estate planning purposes, it's kind of a very niche exception that could possibly apply. It doesn't, from this fact pattern, it doesn't really sound like it applies, but I always try to give the exceptions out there. So, the law's not always black and white. We got all
just in case.
Yeah. But, usually whenever you add someone's name to the deed, it is presumed that you intend to make that property, even if it was previously non-marital, that you intend to make it marital. That's another thing people need to be careful of. If you go to refinance a house and it was a non-marital home, and then you add your spouse's name to the deed, it could become marital there as well. So, if I'm representing this individual, we're going into court with the presumption that that home is now 100% marital, and the other side is going to have to disprove or show the court why it should not be marital, which is going to be very difficult to do, in my opinion. Now, there was a case in town many years ago where this guy was actually a lawyer. He was married to this lady.
Mm-hmm.
They got divorced. She took half the value of the home. He kept the house, but she got paid out half the value. And then they were divorced for a few years. And they saw each other at a bar again. Oh, I miss you. I love you. Yeah, they're got married again. And then as a gesture of his love, he added her to the deed again. Then they got divorced again. Then he paid her out half the value or half the equity in the home again. So he paid this lady 75% of the equity of this home over the course of their 2 divorces. But that just goes to show, when you add the name to the deed, it is presumed that you intended to make it marital again, even if it was previously non-marital, as it was in this individual's case.
Love will make you do some dumb things.
Oh, yeah.
Cost you a lot of money, too.
It can certainly do that.
Wow. He should have just gotten her flowers.
The flowers would have been a lot cheaper.
Yeah,
a lot cheaper.
Absolutely. She completely made out on that deal.
Yeah.
Wow. All right. You are listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk. Mo, what is the best way, if listeners right now, they've got a question for you, they need some advice, what's the best way to get in touch with you now, if they want to speak to somebody now, or if they just got a question they want you to get to maybe next Sunday?
Yeah, if you want to call the office, you can always call the office, 1-800-DeWitt-LAW. It's 1-800-339-4885. There's always someone standing by there who can at least take a message and get it to us so that we can get back to you. And then if you want to leave a question for the show, you can send us an email, askask@dewittlaw.com. Or we'd love for you to leave us a voicemail, nice and easy, 407-536-6737. Yes, 407-536-6737. And you can always text that number as well, and we'll get the text message and answer your questions right here on the show.
Perfect. Got to a lot of them today. We still have another one coming up about uninsured motorist coverage. Also, we've got our Mo Pro Tip of the Week as well. We'll be back in just a few minutes. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
Hey, I just want to say thank Mo for all that he does for all of us BDMs and all here for Tom and Dan. And if you're ever injured on the go, just call Mo.
Brother, we're here at the BDM 2022 Beach Bath. Injured on the go, just call Mo. If you're injured on the go, just call Mo.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. I'm here with Mo DeWitt of the DeWitt Law Firm. Mo's answering your questions this morning. We're going to get to our Mo Pro Tip of the Week, but as promised, got one more here, and this one deals with uninsured motorist coverage. So they want to know, hey, Mo, if UIM covers only my medical bills, why is it necessary if I have total medical coverage through Medicare and VA benefits? Why do I even need it?
Well, first of all, uninsured motorist coverage covers more than just your medical bills. We use medical bills as an example a lot of times because they can be quite substantial. But, it covers lost wages. It covers pain and suffering. It basically steps into the shoes of the at-fault driver if the at-fault driver doesn't have enough insurance. So it covers more than just medical bills.
Okay.
Now, you may have, VA benefits or Medicare benefits, but depending on the types of injuries, the types of services you need, you may need additional services beyond what they could offer. You may need, in-home treatment that may be limited by Medicare or VA, or they may just, even if they have the services, sometimes there's waiting lists. Sometimes it can be difficult to get those benefits. So you want to make sure you're protecting yourself in all ways possible. But again, it covers more than just your actual medical bills. It covers, basically anything, any consequence from the, directly caused by the accident. Right. So, as we've said many times on the show, personally, I think it's probably one of the most important coverages you can have in Florida, because I think we're the only state in the nation that does not require bodily injury coverage. And I know this all kind of sounds just like foreign words to people,
right?
Because if you don't deal with it every day, you, just like I used to, you kind of ignore it. But bodily injury coverage is the coverage on your vehicle where if you hit somebody else and hurt them, that's the coverage that they can go after. So you always want to make sure you have enough coverage personally to cover your assets. But the UM coverage is the coverage that if someone hits you and doesn't have sufficient coverage, that you can then go after, just like you go after that fault person, to cover the injuries and the pain, suffering, and the lost wages and everything else that resulted from that accident.
Gotcha. And that was actually a Mo Pro tip of the week. It's been a couple times over the last several months, and I didn't have it. I checked based on your advice, and I went and got it, and it's not much more.
It's really not much more.
Just to have it for that peace of mind. So, well, let's go ahead and get to this week's Mo Pro tip of the week. What do you have for us, Mo?
Absolutely. So we'll keep it short and brief, but if you're going through a divorce, a lot of times people, there's two sides of divorce. Obviously, there's the scorched earth technique, but a lot of times people just say, hey, I just want to get this over with. I'm trying to be agreeable here. Mm-hmm. And they just kind of agree to something that's not super detailed. But, if something goes wrong in a divorce, it's the divorce documents that are going to control. So this is super important, especially with parenting plans, that you really go through it and think about worst case scenarios. Think about, if you guys cannot agree, is there a provision in the parenting plan that controls, that guides you if you can't agree? Because, hopefully you can take a parenting plan, which is basically the document that outlines your rights and responsibilities with your children. Hopefully you can take that document, shove it in a drawer, and never look at it. Right. But if you and your former spouse, or you and the mother or father of the child, cannot get along, then that's the document that controls. And if there's no provision in there telling you what to do, you're kind of stuck. So, when you're looking at those documents, when you're going through a divorce, you want to make sure those things are super detailed and have provisions as to what happens if you guys cannot agree. If all it says is, hey, we're going to agree and figure this out later, that really doesn't do you any good.
Right. I mean, I've heard you say 100 times before, everything's going off well. You have things like, it seems like you're going to figure everything out together. And then next thing you know, something happens and it changes. And now terms are completely different with each other.
Yep. I mean, the devil is always in the details of these things, and that's where you can really get caught.
Right. Well, another great show right here, the DeWitt Law Review. And I'm not tooting my own horn. I'm talking about you and your advice. The DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk. We'll be back again next Sunday with more of your questions and answers for legal advice. So in the meantime, you can always call the DeWitt Law Firm right here. Call the office anytime at 1-800-DeWitt Law. That's 1-800-DeWitt Law. Also, interact with the show just like we did today. Have all those emails, all those questions. You can send those to ask@dewittlaw.com. You can send them anytime, today, tomorrow, Wednesday, whenever. Ask@dewittlaw.com. Or you can also leave a voicemail at 407-53-MOSES. That's 407-53-MOSES. You've been listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk.
About a year ago, I was in a really bad accident. I got my hand caught in a saw and I lost my thumb. Luckily, the doctors were able to put everything back together. Originally, we reached out to other firms to take my case and nobody would help us. But when we called Mr. DeWitt and his team, they were there to help through the whole thing. I'm extremely happy with the result. Extremely happy with the result. It was an easy process. They made it as easy as possible, and we got the best possible result. Injured on the go? Just call Mo.